Good afternoon, everyone. My name is Mohan Kumar, Central Council Member, Institute of Company Secretaries of India. At the outset, I would like to extend my best wishes of the 77th Independence Day that we all celebrated with full fervor yesterday. Friends, it is imperative that we constantly upgrade our knowledge and our skill set. It is with this thought and intent that ICSI has launched Master Knowledge Series, EEE, Enable, Evaluate, and Excel. Taking the legacy of previous initiatives along with, our institute has also launched 23rd edition of ICSI National Awards for Excellence in Corporate Governance. I would urge all our fellow professionals to urge their companies to apply for this prestigious award. Coming back to the event for today, I'm happy to share that we have already conducted 6 webinars under this EEE series and hope to conduct many more on the contemporary topics of professional interest. Friends, I would like to extend a warm welcome to all of you at the 7th webinar under the ICSI Master Knowledge Series on the topic Share Capital, Buyback, Reduction and Redemption. It's a very well-known topic among the professional fraternity, and at the same time, one bringing plenty of intricacies on the table. Most of us in our line of work have come across issues as different as a thumbprint, none matching the previous one. It is with this thought to provide respite and resolution to our issues. We have our guest speaker for today, Dr. K.S. Ravichandran, Managing Partner of KSR and Co. Company Secretaries LLP. He's a practicing company secretary and a lawyer, heading a team of more than 15 qualified professionals. He is currently serving as independent director in Karur Vysya Bank Limited. His firm, with its offices in Bangalore, Chennai, and Coimbatore, specializes in secretarial audits, legal representations, opinions, transaction advisory, IPR protection services, and dispute resolution. He is also the chairman of Corporate Law Association's Southern Regional Council, and the list is endless. KSR sir, it gives us immense pleasure to have you amongst us here and to guide us on the topic for today, share capital, buyback, reduction and redemption. Over to you, Ravichandran sir.
Very good afternoon to everyone. Probably, I think these 3 topics together will bring into some sort of clarity and in the learning process. We hope to upgrade ourselves. I think that is how I would like to say as a preface. It's a very interesting topic, and the Institute has been creating this platform, which is unique in terms of professionals like company secretaries, because amendments are happening daily. There are various situations which are emerging. You must be able to appreciate that imagination is the key to everything. And you will find overnight corporates bring new requirements, new designs to their schemes, programs, and proposals, which hitherto probably the legislature would not have contemplated at all. That is the beauty of imagination. You and me sitting here or in the corporate's room, we will create schemes, design, structure, organize arrangements, proposals to achieve certain desired results. And these may not have directly been addressed by the provisions of the Act. Probably there may not be any judicial precedent in India or elsewhere in order to support your argument or your scheme or your structure or arrangement. Such is the kind of beauty of imagination in terms of schemes of arrangement, in terms of programs for buyback, for reduction, and of course, the last one is the redemption. When you look at these type of things, over a period of several years, we are reminded about the various things that have happened in the country in this space, whether under the 1956 Act or under the 2013 Act. I would like to give you Mohan Kumar, anything you were saying? Okay.
Nothing,
Clear?
sir. Please proceed. No, nothing, sir.
I would like to start off by saying a very interesting case which currently I am doing for the last. Currently, I'm saying this sentence very wantonly, but for the last 10 years. Okay. That is an interesting case where a public limited company had issued preference shares to another public limited company. And this public limited company, which is the issuer company, has agreed to redeem the preference shares in three, we can say annual installments of at the anniversary of, say, for example, 10th year, 11th year, 12th year, like that. And unfortunately, the holder of the shares, being another public limited company, went into some insolvency type of situation prior to the advent of the Insolvency Bankruptcy Code of 2016. When I say 10 years, you will be able to realize the IBC was not in existence. Since the case is going on currently, so I will give you a sketchy information only in order to, stretch our imagination and understand how things can work. The holder of the preference shares, being a target of the banks for recovery of their dues, left, right, and center, SARFAESI and other proceedings are initiated in order to recover the money. And the issuer company tactfully got some document which we say fabricated to be tested and adjudicated. And on the basis of consent of a person, they say the period of redemption is extended simply by another 5 years for each installment. And when this was done and you come to know about it, the creditors are offended naturally because these preference shares were pledged to them and they were hoping to get handsome money on redemption. And for the last 10 years, prior to the first date of redemption, there was no dividend paid on those shares. That is another important feature of the case. There was no dividend paid at all for the last 10 years and 11, 12, 13 also. And they say there is a consent and they say this has been extended by another 5 years respectively. And by the time they come to know that such a thing has happened, already 1 year has passed. The creditors are now in difficulty and the shareholder company is in stress and it is in the control of the creditors. So in this situation, appearing for the shareholder company, we moved the company law board prior to even company law tribunal coming into force. And during the last 5 years, before the last 5 years, normally we read in the law, the immediately preceding financial year to the immediately preceding financial year. So similarly, the last 5 years, before the last 5 years, during that time, the matter was going on from company law board with various applications and other proceedings. In the meantime, that 5 year is also over. The contentious issue of how this 5 year got extended not being decided, before that is decided, you will find another 5 year has gone without any action on the part of the company, issuer company, without redeeming the preference shares. For the last 10 plus 3 plus another 10 companies saying that there is no profit and therefore they are not able to redeem. Once again, please.
Yes, sir. Yeah. Please continue, sir.
So what happens in the situation is that the redemption never happened and the original issue continues. It has come to NCLT and NCLT is posting it for video could off panilla. I think you can be free. The question is about sharing of certain documents I will be showing. But to finish it fast, what I'm saying is that redemption has not happened at all. And in the case of a company not being able to generate money by way of profits and not being able to make a further issue of shares for the purpose of redemption, redemption is going to be a difficult proposition. So that is what I would like to say. It is a live case, therefore, as it is going on, we do not know what will be, when the case will see the light of the day. Though we saw in the initially when 2016 the Company Law Tribunal was introduced, and we are all probably thinking that within 6 months the cases will come to an end. It has never seen the light of the day because most of the time you will have the bench and the proceedings will be taken up, and thereafter there will be regular bench, and thereafter there will be no regular bench, there will be no bench at all, and all these things keep happening. And in this particular situation, we are discussing about corporate actions. Therefore, the first and foremost thing we should remember is a corporate action which is dependent on an approval process. A corporate action which is dependent on a provision of law which introduces restrictions, prohibitions, and clutches. A corporate action which is dependent on approvals of layers of approvals of various authorities, regulators. These are all not a time-bound process. It is very difficult for anyone to precisely say that this is possible. We'll do it in 150 days, 200 days, 30 days, 40, 45 days. All these number of days are in the book, and it is going to be tough in terms of these type of corporate actions because they are either conditioned, regulated, restricted, prohibited in some respects by the provisions of the Companies Act, by the provisions of the SEBI regulations, and probably there are layers of approvals which will take its own time, and probably there are regulatory clearances and also national company law tribunals are sort of tribunal approvals, and then the usual appeals before NCLAT and Supreme Court. The matter can go on and go on. Therefore, first and foremost thing is a calendar for completing the activity from the drawing board when you first decide that this activity shall be undertaken until the activity is absolutely completed. You will always find uncertainties throwing in, coming in, and therefore, prior to we go into the subject, I thought I'll share with you this experience. The reason is, when you are designing your scheme or a proposal, an arrangement, a program, capital raising program, capital redeeming program, capital buyback program, capital reduction program, whatever be it is, always factor that there are going to be unexpected turn of events. There are going to be uncertainties. Timelines may be drawn, may be redrawn and redrawn. So therefore, programs of this nature are always bound to throw shocks and surprises also sometimes. With this preface, I thought I'll take you to the section 55 of the Companies Act. I am sharing the screen now for the sake of understanding of the provisions. Before you is Companies Act 2013. Let me zoom it a little more. I'll go straight to section 55. Sometimes scrolling will be easier than running through this Control F process. And we are happy that Control F is working because many cases you will not be able to use Control F also. So you will find that issuing preference shares which are irredeemable is not possible. I am taking from the latest one, and so that we can proceed with so many other things. You will find that there is a requirement for authorization of articles for prior to issuing the preference shares. And the 20-year period is specifically mentioned in this particular rule. And you will find no such preference shares shall be redeemed except out of the profits of the company which would otherwise be available for a dividend, or out of proceeds of fresh issue of shares made for the purposes of redemption. Way back, I remember Justice B.P. Jeevan Reddy, in one case, I think it was solvent extracts, some case I remember, a preference shareholder whose shares were not redeemed had applied for winding of the company under the 1956 Act. And of course, a very scholarly judge, Justice B.P. Jeevan Reddy was, who rose to the level of Supreme Court judge. And he said, preference capital is a capital and is not a debt. Even if the redemption has not happened, there is a default on the part of the issuer company to redeem the preference shares. That doesn't create a debt. And therefore, under 433 of the 1956 Act, a winding up petition is not maintainable at the behest of a preference shareholder. So therefore, redemption, if it doesn't happen, you had it. There is going to be a situation with your backs to wall, because the provisions of the law says no such shares shall be redeemed except out of profits of the company which would otherwise be available for dividend, or out of proceeds of a fresh issue of shares made for the purpose of such redemption. And shares have to be redeemed unless they are fully paid, and there is a requirement for creating a capital redemption reserve account. And then let me take you to subsection 3. In the case of a company who is not in a position to redeem the preference shares or pay dividend, what will happen to that? On such shares, if the company is not able to redeem or not able to pay the dividend on those shares, the company may, with the consent of holders of 3/4 in value of the preference shares, with the consent of holders of 3/4 in value of the preference shares, you can see here, with the approval of the tribunal. Next item. On a petition made by it in this behalf, issue further redeemable preference shares equal to the amount due, including the dividend thereon, in respect of the unredeemed preference shares, and on the issue of such further redeemable preference shares, the unredeemed preference shares shall be deemed to have been redeemed, provided the tribunal shall, while giving approval under this subsection, order redemption forthwith, very important sentence, of the preference shares held by such persons who have not consented to the issue of further redeemable shares. Therefore, what is the way out? It looks like if the company is not able to make further issue of shares, or if the company is not making profits, consent of the holders of the preference shares, 3/4. Therefore, whose consent you are going to ask? You are going to ask the consent of the holders of the preference shares, and make a petition to the tribunal, get an approval of the tribunal, issue new preference shares, include the interest thereon or dividend thereon, and then issue for the whole amount, aggregate amount, original capital for, let us say, for 8% for 10 years, another 80% added, so 180%, and sometimes it may be cumulative dividend, and all that we will come to know separately. In that case, you will find that the redeemable preference shares have to be issued in order to do away with the existing default in relating to the existing redeemable preference shares, which could not be redeemed on account of the statutory provisions requiring profits or further issue. And of course, if the 3/4, when I say consent of the holders of 3/4, you will be able to understand that the legislature has visualized that 25% of the holders need not be approving the same, or there may be objections, there may be dissentient shareholders, and while giving such approval under this provision, the NCLT, the tribunal, may order redemption forthwith. When the tribunal is ordering redemption forthwith, held by those people who are not consenting to the issue of redeemable preference shares, you will find that the clutches of the provisions of section 55 with respect to profits or further issue will not apply. Because tribunal is ordering you, redeem it, forget other provisions that come in the way. Number one is that. Number two is, please read this provision once again. Provided that the tribunal, while giving approval under this subsection, order redemption forthwith, means immediate, held by such persons who have not consented to the issue of the further redeemable shares. Therefore, the tribunal, when we say somebody has not to be, knows that there are people who have not consented to the issue of further redeemable shares, you are not going to be stonewalled there. The tribunal shall, please see the language here, the tribunal shall. Therefore, the legislature has visualized a situation where certain people are consenting, and subject that consent being coming from 3/4, you issue redeemable preference shares. And there are non-consenting people, those who are not consenting, return the money to them forthwith. And I am saying, when the proviso is used and the tribunal orders to return the money forthwith, there is no bar with respect to profits or with respect to further issue of shares. In the example which I have told you about a case which is currently running, you will find that the consent of the preference shareholders can never be obtained, because we are the only preference shareholders and we are the people who have objected to the earlier alleged consent, and therefore there is no question of the company, issuer company, going to the NCLT by an application under 55(3) for making a further issue of new redeemable preference shares equal to the amount due, including dividend thereon, in lieu of the existing redeemable preference shares which could not be redeemed. And therefore, we are going to be, the issuer company is going to avoid this provision, and we are going to bank on the proviso to get the money back. So these are all the certain dynamics which will happen in relation to that. By the way, subsection 4 also we can read, because it brings into a situation where your capital redemption reserve account could be used, notwithstanding anything in this section, be applied by the company to pay up the unissued share of the company to be issued to members as fully paid bonus shares. There is a caveat, or we can say carve out available in terms of capital redemption reserve account can be used to pay up if there is any unissued shares to the company. Issued capital, subscribed capital, there is a difference, and that could be used. Now, stopping here for a minute, I will move back to section 47. Let us go to section 47, which is the equivalent of 87 of the 1956 Act. Here you will find, subject to provisions of 43 and all, every member of the company limited by shares holding equity share capital shall have right to vote on every resolution. Therefore, right to vote is enshrined under section 47, and his voting right on a poll shall be in proportion to his share in the paid up equity share capital of the company. Suppose you are holding 1 lakh rupee on an equity capital of 1 crore. Your voting right is 1%. 1 lakh upon crore. Equity value of his shares, paid up value of his shares upon the total paid up value of the shares of the company, equity share capital of the company. So therefore, 47.1 is about equity shareholders' right. And coming to 47.2, which is the redemption related one, you will find every member of the company limited by shares and holding preference share capital in respect of such capital shall have a right to vote only on resolutions placed before the company which directly affect their rights to attach to the preference shares. And any resolution for the winding up of the company or for repayment or reduction of the equity or preference share capital and his voting right on a poll shall be proportion to the share of paid up capital his share in the paid up preference share capital of the company. So his share of the paid up portion of the preference share capital of the company. The next one is very important here. Provided further, I am reading the second proviso on the screen under section 47, where the dividends in respect of class of preference shares has not been paid for a period of 2 years or more, such class of preference shares shall have a right to vote in all the resolutions placed before the company. Therefore, there is a redemption obligation and there is a failure to pay dividend. And here you see the legislature has given voting rights in relation to failure of the company to pay dividends. If the company is not able to pay dividends, immediately this particular proviso can be used, provided the failure has not been paid, the dividend has not been paid, or failure or to pay dividend has continued for a period of 2 years or more. For example, in a company's capital with about 32 crores of equity plus preference, if 17 crore were to be the equity share capital, and let us say about 15 crore were to be the preference share capital, you will find it is like almost 50-50, 54 equity and 46 preference. And therefore, any special resolution contemplated under the Companies Act will not be capable of being passed unless preference shareholders also approve, for the reason that the second proviso to section 47 very clearly says, on all the resolutions placed, they shall have a right to vote. So therefore, voting rights splits between equity and preference, and if dividend failure takes place, there is going to be a costly proposition of preference shareholders having more rights. Sometimes depends on what is the equation between equity share capital and preference share capital. So you will find that the subject of redemption is an interesting subject, but you have to be very cautious in view of the difficulties of the preference shareholders from taking any action other than what is spelled out in the Companies Act. Similarly, for the issuer company, the only way out seems to be having profits and returning it, or making further issue and returning it, or going for the action under section 55(3) if possible. And that action also you would have found 3/4 of the holders of the preference share must have approved the same. So that is the kind of thoughts I wanted to share in relation to the redemption of preference share capital. So having said that, I thought I will take you to another provision which falls under the category of reduction of capital. When we talk about reduction of capital, a reduction of capital is a program which can be undertaken under section 66 of the Companies Act. Let me take you to 66. Reduction of share capital. Subject to confirmation of the tribunal. Therefore, in reduction also, there is a role for the tribunal. Subject to confirmation by the tribunal on an application made by the company. Therefore, company has to make the application. A company limited by shares. A company must be a company limited by shares or limited by guarantee and having share capital, because we're talking about reduction of share capital. And therefore, a reduction of share capital will be possible only if the company has a share capital and by special resolution reduce the capital in any manner. That 3 words you must remember and mark it. Section 66 talks about reduction of share capital. Company must apply. Tribunal should confirm. Special resolution is needed. Company must have share capital and reduce the capital in any manner, no holds bar. And in particular, the company may extinguish or reduce the liability on the shares in respect of share capital not paid up. Limited liability company means what? The amount payable and amount actually paid. The difference is always a liability of the individual shareholder. Therefore, if the company doesn't want that, they can reduce the liability if it is a cash cow. I very distinctly remember long before, about probably 15 years back, a case where the company's board of directors asked me that we would not want such a bloated capital to remain in the balance sheet of the company, because the company's operations are quite the very crystallized. Everything is set, and this is the business model. There is no expansion possibility. The cash requirement is only this much, and therefore we advise the company to convert the capital or equity share capital of the company into deposit in a scheme of arrangement. We didn't propose a straightforward reduction of capital. I proposed a scheme. I remember I wrote it those days in probably about 15 years, 20 years back. And the scheme was for reducing the capital by about 1/6 retention and 5/6 returning. But at the same time, we applied the business wisdom, because 5/6 of the capital to be returned from the balance sheet of the company could remove the cash availability. And therefore, we devised a scheme instead of a plain vanilla reduction of share capital, and said that the 5/6 of the capital which is required to be returned shall be returned over a period of time, and until such returning takes place in the next 5 years, there will be these will be treated as deposits of shareholders, and they will get interest at about 18% per annum. And that scheme went for approval or sanction under the erstwhile 391/94 of the Companies Act, and read with 100 and 104 went to Kerala High Court for approval. And probably that is one of the schemes which where equity capital is converted into loan, and later on deferred reduction scheme was introduced. Therefore, we always say any scheme of arrangement is a poetry, as long as you are able to quietly understand within the contours of the law, you will be able to succeed in getting the necessary confirmation by the tribunal under section 66, or sanctioned by the tribunal under 230, 232 of the Companies Act. So here, a special resolution is sufficient to get a reduction of share capital done in any manner whatsoever. But in particular, you can extinguish the liability to the extent of amount not paid up. You can also do without extinguishing, without reducing liability, without extinguishing or without reducing liability also, cancel the paid up share capital which is lost or unrepresented by available assets. Because there are a lot of companies where the balance sheet is required to be cleaned up, it will have a bloated capital, and on the asset side, supporting assets may not be there of current value. They will be fictitious. There may not be assets which are recoverable, realizable. And particularly after the experience, having handled more than 100 cases in IBC alone, you will find the experience has not been great in terms of the balance sheet reliability. Most of the companies whose auditors have certified, whose board has declared that it is a going concern, true and fair view, ended up in showing assets not being able to fetch the amount required even to pay external creditors, forget about shareholders and forget about equity shareholders. Therefore, it is possible that the assets are lost, it is unrepresented by assets, and therefore to the extent it is not represented, to the extent net worth has depleted, to the extent accumulated losses have come, there is a possibility of reducing and cancelling the paid up share capital so that the balance sheet is reflected properly. Pay off any paid up share capital which is in excess of the bonds. So the 66B2 was the one which I was explaining you, but we chose to use a reduction of share capital clubbed with a scheme of arrangement, because we didn't want to pay off the excess paid up capital on day one, because that will remove the entire cash from the system. So we have introduced an imaginary deferred reduction of capital, so that over a period, without having any liquidity crunch, the money is capable of being returned. So section 66 comes into rescue for several purposes. You will find an imagination is the key in order to use this opportunity. And I remember distinctly, long before a Bombay High Court decision, I think in respect of a particular company, they of course used the scheme of arrangement route also, because quite often scheme of arrangement route may be advisable because of the inherent limitations of section 66. And therefore what they did was, I remember, anybody having less than 20,000 paid up capital, they wanted to remove. Face value of shares were changed to 20,000, and those who are holding less than 20,000 are fractional entitlement, and therefore the capital was returned to those shareholders whose the value of shares held by them, face value of shares held by them is less than 20,000. Probably they wanted to do away with the minority shareholders and consolidate the promoters' holding through a scheme. Similarly, you would have also probably noticed. I'll share the screen for one of the decisions. You can see here, Simpson and Company Limited is an unlisted public company. It was originally incorporated in the 1925, and the main objects of the company are as follows. The capital structure as at 31/3/2019, I'm reading para number 6, is like this, about 11 crores and whatnot. You will find there the 7 crore 37 lakhs 50,000 is the issued, subscribed, and paid up capital. And you will find that there is a provision in the Articles of Association with respect to consolidation and division. And you will find the learned counsel for the applicant submitted the consolidation of share and consequential reduction of capital of the fractions, if any, as follows. This is a very interesting proposition, proposal or program. The Board of Directors meeting held on 25/9/2019, subject to approval of the tribunal, approved a proposal to consolidate share capital into shares of larger amount than its existing shares by increasing the nominal value of equity shares from 10 rupees to 2,500 rupees, so that every 250 shares, if you are holding only, you will get one 2,500 rupee share. This is what I was telling you, the 20,000 scheme. Similarly, here you will find a novel method of removing certain shareholders who are not even holding one share of 2,500. That means unless the person is holding 250 shares of rupees 10 each, he is not going to be issued with one share of 2,500 at all. And therefore, the company introduced this kind of thing. The clause 3 of this is very important. No member will be issued with any certificate for resulting fractional entitlement of a share as a result of implementation of this resolution for consolidation of shares. So, fractional entitlement, how they will deal with it. The fractional entitlement shall be reduced from the share capital, and at a price which is fixed by the company, pre-fractional share, they will be paid the money back. That is where the reduction of capital comes. So therefore, you will find that a valuation was done, and they have found a value of 14,860 rupees per share. So if you hold one share of rupees 10, you're going to get 14,860 rupees. But you're not going to get shares, and you're not going to continue with the company. This scheme faced serious arguments before the NCLT recently, and this matter is now before the NCLAT. You will find that innovatively the Company Law Tribunal gave an order that there is no flaw in the scheme, there is no non-compliance in the scheme, and the emphasis is in any manner. You will see that this language was what I was telling you. The emphasis is in the language is in any manner. So you will find that such type of schemes are being introduced or can be introduced. And in order to give opportunity for the fractional entitlement holders, what the Company Law Tribunal said, you can see at the end. The Company Law Tribunal at the end of the day said trust will be formed. In order to safeguard the interests of the dissenting shareholders who do not offer their shares to the company for cancellation to get the 14,680 rupees per share, the petition company shall facilitate constituting a trust in which fractional shares of the dissenting shareholders shall be vested for their benefit, arising thus shares through an appropriate deed, etc. So what they have done is they have allowed the company to create a trust which will hold the fractional entitlements, and thereafter you are not holding 250, at least 250 shares. If you are having, then only you are getting one share. So this type of resolution for reduction of capital was permitted by the NCLT. Of course, the aggrieved minority shareholders, having felt that they are being chucked out of the company, with which they have been for long, shareholders have gone in appeal, and I'm not sure what is the status of the appeal as of now. But suffice it to say, the reduction of share capital is one of the routes available for the purpose of reducing the capital for the specific purposes which are stated in the section 66 itself, or for any other purpose also. So section 66(1) itself, the one section itself, subsection 1, that itself gives you huge opportunities. It all depends on what is sought to be achieved. And in another illustration, if you see a decision of the National Company Law Tribunal in another matter, let me take you to the Brilio Technologies Private Limited case, which was a 2019 matter. You will find the brief facts on the screen. I have shared the brief facts. You can see there, this is the kind of capital they are having, and assets and liabilities are set out. And the board of directors, para 6, I'll read. The board of directors, I think I can zoom it a little more for benefit of our participants. Hope it is visible. The board of directors of the company on 24th January 2019 resolved to reduce the equity share capital from the existing 21.72 crores to 20.82. You can see the difference. 21.72 crores is going to be reduced to 20.82 crores by reducing just about 89 lakhs of rupees equity shares of rupees 1 from the non-promoter equity shareholders. Here you find the classification. In the Simpson case, they never said promoter, non-promoter. They said those who are holding less than 2,500 face value, the two are less than 250 shares of rupees 10 each, they are going to be checked out. In the Bombay High Court 20,000 rupee case also, it was built on the scheme itself was built on face value being 20,000. And anybody holding not even, let us say 10 rupee shares, 2,000 shares, they are not going to be there in the company. And in this case, it was a classification which was open, and I would prefer this scheme is in a way better and clear as to what is the objective it seeks to achieve. It sought to achieve non-promoter equity shareholders to be out. 89 lakhs 52,637 equity shares, rupees 1. So number is equal to the value from non-promoter equity shareholders for consideration of about 5 crore 61. So approximately you can say it comes to about 6 point something times the shares, 1 rupee plus 5.27. That is what is the securities premium account, and the securities premium account of 15.2 crore should accordingly be reduced to 10.53. So you draw 5.27 per share from the existing SPA, that is securities premium account, and about 89,052,637 from the paid up capital account. So 21.72 will become 20.82. So this was a scheme which was plain and vanilla 66 reduction of capital presented to the NCLT, and the NCLT rejected the scheme. The confirmation was denied. You can read there in the beginning itself, the appellant Brilio Technologies filed this appeal against the order of the NCLT Bangalore, August 2019, saying that the confirmation has to be given, praying for confirmation as NV says under 66(1) of the Companies Act. But the NCLT Bangalore bench dismissed the petition, but with a fresh company petition in accordance with law. The reason why this fresh petition they have The reason is the NCLT Bangalore, in this original order dated 28/8/2019, felt that it must be a scheme of arrangement under 230, 232, basically 230, because it is not a plain and vanilla scheme for reduction of capital. Whatever the premise that was probably running in the mind of the members of the NCLT Bangalore bench was that the premise was that reduction must be across. It must happen not to any specific identified targeted people. Reduction must be happening across. Probably that was the fundamental premise with which the NCLT said it is not a vanilla 66, because in order to be a vanilla 66, you should be able to bring equality amongst all the shareholders. And here, the scheme itself is only for non-promoter shareholders to be exited. Therefore, carefully, probably, nicely, I will also use the word nicely, saying that, it may not be a 66, but it can definitely pass the muster under 230. And therefore, they gave the liberty to file a fresh company petition. But the company people had the liberty of using the provisions for appeal, and they went to NCLAT. And in the Jarat Kumar Jain bench, the NCLAT agreed that Section 66 does not come in the way in which shareholders can organize their affairs. The proposal involves reduction of share capital from selective group of equity shareholders, involves repayment of excess capital which is not required for carrying on the main objects of the company. Such reduction will not cause any prejudice to the creditors of the company. That is what was represented. Now I'll go to the main paragraph. Ground number 4 is one which they have not, probably the NCLT did not reject. So I am not reading that, but I'll read only ground number 5. The only objection, you can see this language here. This is a very important language. You can read it. So the only objection to the scheme is for reduction of capital proposed by the special resolution. This scheme wipes out a class of shareholders, namely non-promoter shareholders. According to the objector, it is unfair and inequitable. The scheme proposes to wipe out a class of shareholders after paying them a compensation which can be termed as so this is the objection. Of course, they relied on a erstwhile very interesting off-quoted Sandvik Asia case for the Bombay High Court, and ultimately the NCLT is of the view that the tribunal, that is Bangalore bench, has erroneously held application for reduction of capital is not maintainable under 66 of the Act. Consent affidavits from creditors is mandatory for reduction of share capital. Securities premium account cannot be utilized for making payment to the non-promoter shareholders, and consent from 117 non-promoter shareholders who are not traceable is required. Selective reduction of capital is not permissible. The tribunal has dismissed it on untenable grounds. Therefore, we hereby set aside the impugned order passed by the tribunal. This is what is the decision of the National Company Law Appellate Tribunal in this Brilio matter. So, one thing we are able to understand in Section 66 is it also gives you a number of opportunities to do your working in order to achieve a desired objective. It is, you are not probably circumscribed by the purposes specified in particular under Section 66(1). And also, I think I should take you to another provision also. You will find in clause number 10 of section 230, this is the language used here under section 230. You can see here, no compromise or arrangement in respect of any buyback of shares, securities under this section. Any buyback under this section shall be sanctioned by the tribunal unless such buyback is in accordance with provisions of section 68 of the Companies Act. So we are going to move to buyback, but before that I thought I'll make you note subsection 10, which specifically requires a buyback must be in accordance with section 68, and if it is not in compliance of section 68, there is no buyback at all. No buyback program will be able to be pursued, implemented without in any manner of doubt, without being in compliance of 68, no to buyback. At the same time, while talking about buyback under subsection 10 of section 230, section 230 also explained under subsection 12, for removal of doubts, it is hereby declared that the provisions of 66 shall not apply to the reduction of share capital effected in pursuance of an order of the tribunal under this section. So, very clearly, reduction of capital can be a scheme of arrangement through section 230. The dividing line is very thin and it is not necessarily a separate provision. It could be added here. For you can see here in 230 itself, an explanation says like this. You will find here the explanation. The company, for the purpose of this section, arrangement includes a reorganization of company share capital with a consolidation of shares. So it is an inclusive definition. Reorganization of the company share capital by consolidation of shares of different classes or addition of shares into shares of different classes or by both these methods. So 230 is an interesting provision which may be noted while we are discussing about 66. Let me go back to 66 now. So we have read about the subsection 1. Number 2 is the proviso. No reduction shall be made if the company is in arrears of repayment of deposits accepted by it, either before or after the commencement of this act, or interest payable thereon. So whenever you are thinking about reduction of capital, we have already told you that you should remember there is no problem with respect to deposits. Next, the tribunal will give notice to the this thing and all. This what I think is there is a very brief presentation on this particular subject. I will take you through the provisions for covering both provisions as well as procedures. So far as the reduction of share capital is concerned, listed companies must remember under LODR they have to comply with certain things. So I will take you to the LODR also, just for the sake of understanding. So let me take you to the LODR first. This is the latest one, the amended LODR, and I am straight away going to this paragraph. Regulation 11. It is there on the screen. You can look at it. The listed entity shall ensure any scheme of arrangement, amalgamation, merger, reconstruction, reduction of capital to be presented to court or tribunal doesn't in any way violate, override, limit the provisions of securities laws or requirements of the stock exchanges. So therefore, in the case of listed companies, when we are talking about section 66, we should remember the regulation number 11 also. Please remember this particular 11, and before I take you to the next one, I will go to 37. Scheme of arrangement. Without prejudice to the provisions of Regulation 11, the listed entity desirous of undertaking a scheme of arrangement or involved in a scheme of arrangement shall file the draft scheme of arrangement proposed to be filed before any court or tribunal under section 391(94) of the Companies Act 1956, 101 of the Companies Act 1956, 230, 232, 233, 234 of the Companies Act 2013, section 66 of the Companies Act 2013, which is what we are discussing, reduction of capital. Whichever is applicable, file with the stock exchanges an non-refundable fee and get the no objection letter filing such scheme with any court. Therefore, before filing the scheme with any court or tribunal, under regulation 37, you must be able to get the NOC from the stock exchanges. The listed entity shall not file any scheme or any reduction of capital program under 66 of the Companies Act 2013, whichever is applicable, unless it has obtained an NOC from the stock exchange. NOC means no objection letter. And the listed entity shall place the no objection letter issued by the stock exchanges before the tribunal at the time of seeking the approval of the scheme of arrangement. Validity, provided the validity of the no objection letter shall be 6 months from the date of issue, within which the draft scheme of arrangement shall be submitted to the court. Therefore, it must escape from the hands of the company to the tribunal within this period. So, number one, you cannot propose to seek the confirmation of the tribunal for reduction of capital, a plain and simple reduction of capital itself under 66(1), unless you are able to secure the prior no objection from the stock exchanges where the securities are listed. The listed company or entity shall ensure compliance with other requirements specified by the board. Board means SEBI from time to time. So remember, there is some more to come. And upon sanction of the scheme by the tribunal, submit the documents as prescribed by the SEBI. So therefore, requirements specified in order to understand reduction of capital in relation to a listed company, a listed entity, otherwise, there are something more to be done than merely what the Companies Act requires. Now I will move to a circular, which is a master circular on this subject. I am not going to read out the whole of this circular because it is a circular with some 28 pages, and you will find the date is visible to you, 20th June 2023. This is a master circular, which was probably you would have remembered that March 2017, there was the old circular. Now it is consolidated into master circular, and they have provided that these schemes of arrangement, if there is anything, the method followed is like this. Regulation 11 of the listing regulations provides that any scheme of arrangement, amalgamation, merger, reconstruction, reduction of capital to be presented to the court does not in any way violate, override, limit the provisions of securities laws or requirements of stock exchanges. Regulation 37 of the listing regulations provide that without obtaining the letter, here it is written as observation letter or no objection letter, before filing you should not file it. So therefore the circular is very clear about what is to be done and requirements to be fulfilled by the listed entity in relation to scheme of arrangement. You can see here submission of documents. You can see here what are the things to be given, and in respect of each and every aspect of it, I think here information is provided in this circular, master circular. I am not reading out the whole of this master circular, but suffice it to say, this particular circular is very handy and it gives certain interesting things with respect to what the draft scheme, how the SEBI will look at it, what stock exchanges must do it, and what they have to do it in order to meet the conditions required for getting the observation letter or the no objection letter with respect to the reduction of capital and other things. So in reduction of capital and all, this type of exchange ratio and all will not come. But there is a master circular, there is a clarity with respect to what the stock exchanges will do and what the provisions require you under the Companies Act and also under the listing obligations and disclosure requirements regulations 2015. Now I'll move back to the Companies Act. Now you here in the Companies Act you will find subsection 3. The tribunal may, if it is satisfied that the debt or claim of every creditor of the company has been discharged or determined or has been secured, make an order confirming the reduction of capital. Therefore, if somebody is asking me, what is the most important feature of section 66? If someone is asking me, what is the most important thing the tribunal will see? Rather, the board must see. Subsection 3. If it is satisfied that the debt or claim of every creditor of the company has been discharged or determined or has been secured or his consent is obtained, then you make an order. So therefore, the one single aspect we must remember under 66 is whether the scheme will cause jeopardy to the interests of the creditors of the company, irrespective of whether secured or unsecured. Most important breathing point of section 66 is in subsection 3, and what the tribunal should see, you see it in advance. And here you should be able to show that the company is solvent, get the consent of the creditors, or pay off the creditors, or you do it, secure their interest in some way or other before going for any reduction. Because you remember, after the advent of the Insolvency Bankruptcy Code, Section 53 of the IBC is a talking point in most of the decisions. Previously also these provisions are there, they were there under the Companies Act, they are there in the Companies Act. But the waterfall provided will give you very clearly that the junior most are the shareholders. The junior most are the shareholders. Maybe preference shareholders, thereafter equity shareholders. But junior most shareholders, creditors' rights are first protected in insolvency, in winding up. Therefore, if shareholders want to take away their money, they must necessarily ensure that in the event of winding up, they will get that money to get it back. Because in the waterfall, there are so many seniors before that. That is the way I thought, before I go to the presentation for the purpose of 66, understanding 66 in a granular way, 66.3 must be told to you. Though you would have already read it, my stress on 66.3 is because that is the driving force of a program of capital reduction at all. That is the driving force. Now let me go to the PowerPoint presentation on the reduction of capital. You will find here steps and timeline involved. This is hurriedly prepared. I will be sharing it with our institute also. Probably everybody will be getting a copy of that. So don't worry about it. And if time is available, I'll do improvement also. Let me see it later on. You will find that I have divided this in different phases. Application to the tribunal. You will find these are all the requirements you need to attach the memorandum, article, certificate, resolutions, and whatever declarations, etc. And list of creditors, central government notice, ROC, SEBI in case of listed entity, notice to creditors, publication of notice, when in the newspaper, in the website. All these timelines are there in the first column. You will see within 15 days, within 10 days, like that we have put some timelines. And these timelines are also very important and interesting. All forms are also mentioned here. RSC 1, 2, 3, 4, 5. Reduction of share capital is what is meant by RSC. Phase 2 is you will find the representations coming from certain quarters, tribunal, and then you see there is no objection. There will be order confirming the reduction of capital, and the tribunal has powers to give such other directions as it may think fit, and you get the order and file it with ROC, file the minutes as approved with the NCLT, and file it with ROC. Certificate will be issued in RSC 7. Thank you. So you will understand that so far as reduction of share capital is concerned, it is pretty clear, and you have to make up your mind whether it is going to be a vanilla scheme. You have to make up your mind whether you will be able to secure the special resolution for the same. You have to make up your mind whether creditors' rights are going to be prejudiced in any manner whatsoever. You have to make up your mind with respect to the program coming within the specific instances mentioned therein in 66.1, or it is something beyond. If there is something beyond, would that be proper to deal with it under section 230 or stop with section 66 itself? So these are all some thought-provoking aspects of reduction of capital. Having said that, I have already drawn your attention to two provisions, that is subsection 10 of section 230 and the explanation under subsection 12 of section 230. So a buyback program can never be allowed through a scheme of arrangement in disguise unless you are able to show that 66 is complied with. So buyback program is slightly complicated, but buyback program doesn't involve any approval from the tribunal, any confirmation from the tribunal, unless you are going with a 230 scheme and incorporating a buyback program in part of the scheme of arrangement, and you are able to show 68 is also complied with. So that is how the buyback program will be forming part of the scheme of arrangement. Otherwise, it won't come. So straight away, let us quickly go through the Companies Act provisions with respect to buyback. Power of the company to purchase its own securities. All of us are aware that buyback can be done with money in kitty. That is very important. A reduction of capital without any involvement of paying cash at all is possible. A reduction of capital structured as a scheme of arrangement is possible. A reduction of capital in lieu of that a deposit was created by me in one of the cases. Similarly, something else could be issued. But insofar as buyback is concerned, the share capital stands extinguished to the extent of the shares bought back, and money goes out of the system of the company. So normally, the buyback program involves cash flow, cash outgo. Cash outgo is the very important aspect to be considered. If you are a cash-rich company, instead of looking at dividends, a buyback program can be also considered by the promoters, the board of directors of a company. We are aware of the, Reinforces buyback, Sun Pharma buyback, and recently the L&T proposal, previous L&T proposal, and the issues surrounding that. Probably you must be able to remember the standalone and consolidated debt equity ratio issue was the cause for the L&T's problem at that time. And buyback program is also resorted to consolidate the holdings of the promoters. And also it is resorted to get more EPS per number of shares, because post buyback, the revenue streams will be there as originally estimated, it will go on, but denominator will be reducing to the extent of the shares bought back. So since the denominators reduce, the given net worth, given profits, given earnings per share will improve. Valuation will improve. Therefore, normally when listed companies, when you talk about buyback, they will always go with a premium on the ruling market price. If the market price is X, there will be definitely X plus something in order to make the buyback program attractive. And another thing we have to remember is, with the amendment to the tax laws, the company pays the buyback tax. So therefore, it is easier in the hands of the recipient. When money comes, he is going to be not having any tax issues coming in. So when the surrendering of shares take place, buyback program gives shareholders the distinct advantage for gaining the tax advantage, because company pays the tax on buyback, the 20 plus some tax and all. On the other hand, in dividend, DDT was there, but it is moved back to the shareholders' hands. So buyback program is interesting. Buyback program is probably, particularly when you talk about unlisted companies, we are finding buyback program to be very easy and maybe next to only to declaring dividend. Because in dividends, probably it is very easy, and interim dividend also can be declared. Immediately thereafter, if you need to pay the money which is available in the kitty, not immediately required, you can always look out for a buyback program, because a buyback program is something which can happen immediately. So in the listed company, of course, there are some more formalities. So there are some more complications, which we will deal with it separately. And Section 68 says that a company may purchase its own shares or other specified securities in a buyback program. One, out of free reserves. Two, securities premium account. Three, the proceeds of the issue of any shares. The proceeds of issue of any shares, other specified securities, provided no buyback of any kind of shares or other securities shall be made out of the proceeds of an earlier issue of the same kind of shares or the same kind of other specified securities. Now, so far as the subsection 2 is concerned, which is the most important section, in 66, all other things are only additional points and subsequent procedural aspects. Most importantly, section 68, you have to remember the subsection 2. Number 1, there should be authorization in the articles. That is not a problem in understanding. Problem may be there. If it is not there in the articles, you will have to amend the articles. But I am coming from the point that to understand there should be an authorization in the articles is not a difficult thing to understand. And a special resolution is required. That is also not a big problem. If special resolution is passed only, you can go ahead with the buyback program. But the special resolution is not necessary if you are restricting your buyback program to, let us say, 10% of the total paid up equity capital. So 10% or loss, I mean, that is how the screen is showing, but it is not loss. You need not be at loss and wondering what it is less. Section 68. I don't know if you have noticed this spelling mistake in the in front of you. You are able to see that E and O? Okay, let me take it as seen. Such a buyback has been authorized by the board of directors in the case of 10%. Otherwise, shareholder resolution, special resolution is required, and the buyback is 25% or less of the aggregate paid up capital and free reserves. So the quantum of buyback can be 25%. And in respect of buyback of equity shares in any financial year, the reference to 25% means with respect to the total paid up equity share capital in that financial year. And the ratio, debt equity ratio 2:1 is what is the ideal one. Twice the capital. Debt cannot be more than twice the capital and free reserves. Capital and free reserves. Provided central government may by order notify a higher ratio of debt equity that we will see later on. Fully paid up shares can only be bought back, and the buyback of shares, etc., is in compliance with SEBI regulations, which we will come back separately in the case of listed companies. And so the rules are also there under the Companies Act. They are also required to be followed, and no offer or buyback shall be made within a period of 1 year, reckoned from the date of the closure of the proceeding of a buyback. So notice, what are the things to be disclosed there? You can notice the same. And so far as the subsection 4 is concerned, what is the period within which buyback must be completed? That also you will be able to see. Next, buyback may be from existing shareholders. Always subsection 5, everybody will think. Buyback may be from existing shareholders. Who else can surrender it? Only existing shareholders can surrender it. But the point is, under 5A, on a proportionate basis, that is very important. What they are talking about is, it may be from existing shareholders on a proportionate basis. So when you are offering buyback program to the shareholders, the 25% or 10%, whatever you are saying, is like a proportionate basis you should be able to. The individual may be surrendering more than that also. He can say, I am going to sell more if there is a possibility, and some people are not surrendering, that number can be used. Then open market, then under stock purchase scheme. Now, insofar as a resolution is passed, registrar filing and declaration of solvency, etc., these are all forms are available. We can show that buyback program, the chart is available, which will show you the information with respect to how this buyback will go, what are the provisions, procedures, etc. Then destroying of certificate, extinguishing the capital, all those things are usual process. So I'm not going to run it through. Thereafter, you file the with the registrar return containing the particulars of buyback, and then once it is done, the buyback is done. So in 68, appearing to be an ordinary task is probably slightly complicated, but if you are having the cash and your program is going to be within the limits, I don't think it should be a big problem with respect to that. This 25%, 10% is one thing which you have to remember, board meeting or special resolution. The other thing is about what is the amount to be invested on this buyback, how much money is required. And what is the timeline within which you are going to complete the program? And the articles and special resolutions, board resolutions, and returns, filing, extinguishing, destroying, recording, procedural in nature. At this point of time, let us look at another file with respect to the procedure for buyback. 68, 69, 70, relevant rules, rule number 17. You will find that the securities premium account reserves, etc. can be used. And you can do it from the existing shareholders on proportionate basis, open market, etc. Buyback is required to be authorized by articles. Valuation must be obtained from registered valuer. Audited financial statements must be available. Shareholders' consent must be obtained. And debt equity ratio cannot be worse than 2.1. And the time lapse should be 1 year. And also, you will find the procedure is first we see the articles, we see the board meeting, we see the general body meeting, we see the buyback resolution, MGG 14 is filed, you file the declaration of solvency is filed, and a letter of offer is filed with ROC, you give the letter of offer to the shareholders, you declare the offer period, verification of the offer, and transfer the certain sums into capital redemption reserve account, extinguishment of securities, and closure of then you file the forms for return of the buyback is over, and registers and records to be maintained. You will find a register of shares which are bought back, and the register must be authenticated by the company secretary. And there are certain other obligations which are specified in rule number 1710 of the SCD rules 2014. So those things also we can remember as per the rules. You can see the item number B, company shall abstain from issuing new shares by way of bonus shares. These are all important things you have to remember from the date of passing of the special resolution authorizing the buyback till the closure of the offer. And also what are the things to be ensured. One thing you have to remember is, I have highlighted it for your reading purposes. So you cannot withdraw the offer. Secondly, money that is borrowed from banks and financial institutions, that cannot be used. Okay, so this is a very convenient chart. I have given you calendar of events also. What are the things to be kept ready? I think this is a ready reckoner. We can probably share it with our participants here. Mohan Kumar, we will try to improve it and send it across for being shared to the benefit of our members. Before I move to this listed companies. So far as buyback regulations are concerned, of course, these regulations, all of us had something to cheer about because you find there was an amendment of March 2023 which gave us some interesting thing. A secretarial auditor is supposed to be issuing some certificate with respect to this buyback program under the SEBI buyback regulations. So that is one interesting thing which all of us had seen. And this regulation is one where you will find 2025 also, because this buyback through the open market purchase, you will find, let me go to that provision, open market 15 or something. Yeah, 16. Buyback through stock exchange. See, one of the methods is to buying back from the open market, having nationwide trading terminals. If the buyback is made, what happens is the buyback of the shares or other specified securities through the stock exchange shall not be made from the promoters and persons in control of the company. So this is one important thing you must remember. And better than that, you can remember the other one. The buyback shall be made through the order matching mechanism. That is all or none method. That is, the order must be matching. The company will be the purchaser. The screen will show the company is buying, and disclosure, filing requirements and timelines are also given in this particular class. And then here one 2025 was there. Yeah, it's here. Opening of the offer on the stock exchanges, the identity of the company as a purchaser shall appear on the electronic screen when the order is placed. Number one. Number two, the buyback offer shall open not later than 4 working days from the record date and shall close within 6 months if the buyback offer is opened on or before the 31st March 2023. This particular class is not of any use because it is about buyback offer opening on or before 31st March 2023. Now go to the next one. 6 months has become 66 days. If the buyback offer is opened on or after April 2023 till March 31st, 2024. So you've got another 6 months, 7 months now from September to March 2024. 66 days from what the buyback offer shall open for not less than 4 working days and shall close. That is what they are saying, within 66 working days. And the next one is still interesting. 6 months became 66, 66 became 22. Within 22 working days, if the buyback offer is opened on or after 1st April 2024, before 31st March 2025, and the proviso is very important. The proviso says, with effect from 1st April 2025, the option of open market buyback through stock exchanges shall not be available. This is the important proviso, shall not be available to any company if the offer has been opened and it is not before the, except in cases where the buyback offer is opened on or before the 31st March 2025. So if you have opened it probably on 31st March 2025, the last date, 22 days, it should be available, and that will be the end of it. But you can never have this program of buying from the open market from 2025. So that is the one thing I thought I'll share with you with respect to the buyback. And let me go to the very, very brief PowerPoint presentation on this. Buyback of shares, I have already explained about the purposes, and also I'm not reading it out. There are laws which are Companies Act, Rule 17, as well as the Regulations 2018. You will also remember that the buyback, some circular was there in relation to the buyback of securities regulations 2018 of the SEBI, 8th March 2023. So you must also remember the 8th March 2023 circular of the SEBI, which provides certain things which you can note. And modes of buyback, existing shareholders on proportionate basis, we have already seen for unlisted companies, open market, and purchasing through the stock purchase dog. Whereas in the case of listed companies, you will find that there are tender offer and whatnot, like the open stock exchange purchase extra. Similarly, Companies Act provisions will always apply. And this capital redemption reserve requirement and all is applicable. In terms of SEBI, you will find there is a default, repayment of deposits, no buyback. There is redemption of debentures or preference shares, no buyback. There is a default in payment of dividend, no buyback. And in respect of repayment of term loan to financial institution, again no buyback. So there are a lot of annual returns and other clauses also. Buyback is prohibited. So you must remember, buyback cannot be done through an investment company, subsidiary company. So this particular slide is a very interesting and important slide. It gives you can buy back when these situations are seen in front of you. And in respect of listed companies, the tender offer and open market offer, we have just read about it. And in respect of reservation for small shareholders, 15% of the number of securities proposed, there is a this thing, or number of securities entitled as per the shareholding, whichever is higher. So remember that there is the process is also there in this particular slide. And miscellaneous provisions, if you see promoters in tender offer, promoter intends to offer his shares. I'll make it as a full-fledged version. A promoter intends to offer his shares or other specified securities. The quantum of shares or other specified securities proposed to be tendered and the details of their transactions and their holdings the last 6 months prior to the passing of the special resolution for buyback, including information of number of shares, etc., the price, etc. So there is a special provision with respect to promoter intending to offer his shares. In respect of the buyback through stock exchange, you will find the buyback of shares through stock exchange shall not be made from the promoters and persons in control of the company. So this is a very important requirement with respect to this. Other things I have already explained to you. Now, so far as the illustrative case of Infosys is concerned, the first buyback of shares of the Infosys post 2013 Act came into picture. It was a repurchase at 13,000 crore in December 2017, and subsequently in 2019, 8,260 crore. And buyback price is written there, 747.38 is the open market route. I think they have covered both the tender offer route and the open market route. And Infosys board approved about 9,200 crore buyback plan, and the offer was closed in 2022 September. In September buyback, the Infosys announced it will buy shares worth of 9,300 crore. Of course, there is a taxation, there is a exercise, which is now I told you better than the dividend. Some interesting provision is there. So far as the reduction of capital and all, I have already completely explained to you, including this Brilio case, and the redemption also I have completely covered. With this brief discussion on the, I am saying brief, even though I have taken more than 90 minutes. The reason is, these are all the topics where, as I told you, n number of opportunities, n number of challenges, n number of uncertainties. All the three are there, and therefore it is interesting to work in this field, because you must have a lot of uncertainties to get that kind of shocks and surprises that drive you to doing the job, the challenges and opportunities. So thank you very much, ICSI, for giving me this opportunity of refreshing myself with all these provisions and explaining to our friends on these on this program as much as possible in the 90-minute time. Thank you very much.
Sir, Ravichandran, sir. Yeah, there are few questions, sir. We would like you to take those questions.
Yes.
Sir, another thing is, see, subscribers, sometimes they subscribe to the shares, but thereafter they don't pay the money. In this case, one of the member has asked, what is the recourse? Because from the day one, he becomes a subscriber, he becomes a shareholder, but he doesn't pay the amount. So forfeiture, or what is the remedy available? One of the member has asked, sir. Though not directly connected to the topic which you, but generally on share capital they are asking. Hello, sir. Ravichandran, sir, your mic is muted.
Yeah, I have understood that. What you are saying is a typical case where the subscriber has failed to pay.
Correct.
Now, in case the subscriber has failed to pay, how will you comply with the this 10A requirement?
Correct.
For commencement and all.
Correct.
That is also a problem, no?
True. Yeah, correct.
See, I can go on talk about this type of things because I have handled a lot of NCLT matters.
Yes,
And particularly, I would expect our friends to read the case law on two things. One is an interesting case law in Abdullah versus Mizon Realtors, which I argued before the NCLT Chennai bench, and I argued before one second, I need to sign something. This one, no? All pages?
Hello. Yes, sir.
Yeah. I was telling you that Abdullah Mizan Realtors is a very beautiful case where there were two shareholders, each one have subscribed to 500 shares, and only one person has paid out of the two. And this was a big matter which went for, I can say, years, and I argued before NCLAT also, and it went to Supreme Court. So all the through, from NCLT to NCLAT to Supreme Court, I was able to establish the case, because a subscriber who has not paid his money is not having, line of arguments I am saying, any property in the shares for which he has not paid a rupee. So once a person has not paid for his shares, if you apply your mind on the whole of the Companies Act, you will find nowhere a person not having paid his money is entitled to anything. Only problem which arises is, in that case, there was one shareholder, two shareholders, two subscribers, two directors. If you are having everything is two, what will happen? So that is where the one shareholder has to approach the NCLT and remove the other shareholder by constituting a board, and after giving notice for this, because being a subscriber, he already undertakes to pay for the shares. That is what the memorandum's subscription clause itself says. If you remember, we the subscribers hereby undertake to pay for the shares you are subscribing. And in view of the amendment, it is also a debt. So therefore, even though it may be treated as a debt, that does not mean an unpaid, completely unpaid share capital will be shown in the balance sheet on the liability side, and debt on the the asset side, as if it is a money due from the shareholder. So this one case you can read, it will be very, very interesting, because I have pointed out to NCLT across the provisions of the Companies Act, no right flows, including voting right in a general body meeting. So therefore, the shareholder is doomed forever, and he can be removed through a process in the normal course. I don't subscribe to the view that there will be a calls, because calls, Mohan Kumar, when money is payable on a particular issue of shares, calls are structured to receive a particular portion on application, another particular portion on allotment, and another particular portion on first call, second call, and all. That kind of a call is what the normal articles of association also contemplate. Here, the whole of the money is payable, and this guy is not paying. Therefore, do not confuse with normal calls and procedures related calls in the Companies Act, in the Articles of Association. Even Table F will say this. Similarly, you can read also another case called, the green dot. There also the same type of situation. I argued, and it went up to Supreme Court, and all through we were able to win to remove the shareholder who has not paid for his shares. Both cases, it went through all the three circuits, and all three circuits I only argued except in Supreme Court, because I'm practicing company secretary, so I cannot go before the Supreme Court. Yes, sir. Thank you.
Sir. Next, few more questions, sir. We will take for another 5 to 10 minutes some few questions.
Okay.
Is stamp duty applicable on buyback of shares?
Buyback, I don't think that there is any stamp duty involved because we are not issuing shares, we are removing the shares. If you see the Stamp Act in terms of extinguishment of right, there is some provision for this, but in my opinion, it is not coming. But I can check it once again. Okay.
Okay. Sir, whether valuation is required before redeeming the shares, one member has asked.
No.
Yeah.
No.
Whether a company can issue preference shares having 0% coupon rate.
It is possible, sir, because you are trying to overcome 47 problem. It is possible. This can be structured. 47, your dividend, if it is not paid, there is a voting right for the preference shareholders. So here company may issue, but the issuer company may structure it that way so that dividend non-payment doesn't arise.
Okay.
That is the reason for that.
Sir, one more question. While issuing preference shares, can different percentage of dividend be given for each year as agreed mutually between company and preference shareholders? For example, first year 8%, second year 10%, third year 12%, like that. Whether they can agree like that?
Yeah, absolutely possible. It is all about issue of shares and terms of issue. Please see, the Companies Act does not come in the way of your terms of issue of shares at all. It doesn't even say you should not pay more than this dividend and all. It only talks about the period within which it should be redeemed and how it should be redeemed. And if you are not able to redeem, what is the provision available? Number one, 20 years. Number two, capital must be raised, further issue must be made for redemption, or profit must be available for redemption. Number three, if you are not able to redeem under 55(3), you can go to the tribunal, issue fresh redeemable preference shares. So under the Companies Act, there is no talk about dividend rate being different for year 1, year 2, year 3. That could be the terms of issue of preference shares.
Sir, one more question. Can buyback be made after issue of bonus shares?
I don't think there is any problems.
Okay.
Buyback and dividend, any question together?
No,
Nothing.
sir, not much. In case of capital reduction, is it compulsory for a company to reduce its share capital, or it can reduce its reserves and surplus and no share capital at all by paying cash?
Reduction of share capital is what comes under 66. If you don't want to touch the capital, but you want to remove the reserves against unrepresented assets, then go under 230 only as a scheme of arrangement. There is no proportionate drawing from capital and reserves.
Okay. If, as per the scheme approved by court for reduction of capital, non-promoter shareholders has not collected their amount per share, and amount remained with company for more than 7 years, whether the company is required to transfer such amount to IEPF or to hold the same as liability. If amount to be transferred to IEPF, how it can be transferred as no provision of reporting such amount?
I think if I understand the question correctly, we are talking about these untraceable shareholders.
Correct.
That is why I have referred to that Brilio decision, which clearly talks about untraceable shareholders, capital is being reduced. And if they are remaining as untraceable, money will go to IEPF as per the scheme itself.
Okay. Sir, one more question they are asking, 47 subsection 2 second. So they are asking what is considered as a failure of a company to pay dividend in case of cumulative preference shares, non-cumulative preference shares. What is considered as failure to pay dividend in both these cases?
That is where the difference between 87 and 47 comes. 87 of the 1956 Act distinguished between non-cumulative and cumulative. They gave the 2 years, 3 years difference. Whereas under 47, if dividend is not paid for 2 years consecutively, year 1 and year 2, the moment that happens, voting rights accrue to the shareholders for all the resolutions.
Yes. Okay, sir. Thank you very much. You have shared three different topics and different presentations and topics where a lot of issues, a lot of practical difficulties, both our practicing company secretaries and company secretaries in employment will face. And you shared a lot of case laws, practical cases which you handle, and so much of insight. We sincerely thank you for taking your time and always be. You are with ICSI whenever ICSI needs you in any form, not only webinar, even at committee level or whatever support required. You have been doing. Thank you very much, sir. More than 13,500 people are attending this webinar, and I'm sure all of them will be benefited members. Soon we will once again meet in this webinar series. We sincerely thank you for the continuous support you have been providing for the EEE series. Thank you very much.
Thank you. It was my pleasure. And once again, happy Independence Day to everyone.